in this case, there was a doctrine, or sorry, there was an act called Punjab Excise Act, wherein it was a very colonial act which was prevalent since so many years. Well, there was colonial rule as well. Okay, even post independence, it was prevalent, and it was challenged thereafter in 1999 because it was again arbitrary, it was discriminatory. One of the clause which said, which was highlighted in this case, was that the employment of any man under the age of 25 years or any woman in any part of an establishment in which liquor or any other intoxicating drugs was being consumed. So it just not restricted, it discriminated as well the position of women, and denied all the women on the basis of, no, they were not treated equally. They were discriminated on the very basis that they were not given equal opportunity, as well as not given equal status as compared to men. So section 30 of this act read that any person who is under the age of 25 or any woman, they are not supposed to be employed in establishments which are linked to liquor and any intoxicating drug. So this was, the court prima facie observed that the challenge provision was a pre-constitutional law. That is, this section had come into force before Article 14 and 15 were guaranteed through the fundamental rights enshrined in our Constitution. So, but it was declared unlawful. So this law was again judicially reviewed, and it was held that it is unconstitutional. So one of the few contentions argued was that the legislation was to ensure security of women, to which the court observed the following: that the present law was just law ends up victimizing its subjects in the name of protection. So in order to protect women, they were not supposed to be employed in liquor or any intoxicating agencies. But yet again, it was held that in regards to interference prescribed by state for pursuing the ends of protection should be proportionate to the legislative aims. They should provide protection measures, or they could have done any other protective measures in regards to the same, but that did not did not mean that they should not be treated equally as per the status as well as opportunity employment opportunities. Is it clear? Yes, next slide, please. So again, in these two, again, Mohammed Ahmad Khan versus Shah Bano Begum, it is a very, very famous case in which the maintenance was provided to the Muslim women, which was earlier denied because they were not inclusive of Muslims, and Muslim law prevented the same. So again, this in this Shariat Act was challenged, and it was declared that through section 125 of CRPC, even Muslim women can have the right to maintenance, right of maintenance from their husbands. The next case is again judicial review of executive actions, that is Ram Jawaya Kapoor versus State of Punjab. So in this case, it was held that basically it is a case that enshrines that what constitutes executive in the Indian constitutional scheme are there. So in this case, in 1995, whenever there is an action of executive is challenged, the judiciary can scrutinize the action and see its legality. The unlawfulness activities cannot be permitted as a lawful measure, even if it is done through the executive. Members elected by the people need to show more accountability, right? So again, test for reasonableness was again important in this case. Just a moment. Yes, can we have the next slide? Sorry, there's some noise around. So what are the limitations to judicial review? Judicial review, yet again, is not absolute power. It is expressed and implied limitations are there. And for example, of express limitation is the ninth schedule of the Constitution. Again, the ninth schedule is not supposed to be judicially reviewed. And what does constituents of the ninth schedule say? Anybody who knows regarding the ninth schedule? The ninth schedule is prevented from any judicial review. And why is it so? Anybody who knows any answer? No? So we are just left with 10 minutes. Why did, okay. Why so? We have to start with another session. So please, we will have to do another. Can you please extend the time? You are, if it's possible, or we'll start another meeting thereafter because we are yet to start with our own today's task. Okay, yeah, we can start another meeting thereafter. You can mail the link to all of them and we can just finish off with this slide today. So ninth schedule says the first amendment of the Constitution added the ninth schedule. So it inserted to the Constitution that the law, land reforms, and other present measures could not be judicially reviewed. And again, it is not, they are not allowed to be challenged in any court of law. And there was a long debate thereafter, and there were many cases, which again, we will discuss in amendments to the Constitution thereafter. So can we have the next slide? So finally, we'll like to sum up with this. The maintenance of good democratic traditions just again depends on the continuance of vibrant judiciary. A written constitution vesting judiciary with the responsibility to guard the constitution and democratic spirit would secure democratic governance in the country. It is possible only through judicial review of executive as well as legislative actions. Thereafter, judiciary has to maintain an accountability and independence as well. So other branches of the government have to guarantee independence to the judiciary, and that is the reason we have judicial review.